Good morning, Your Honors. I will share a presentation as well. Hopefully, it is visible. And I want to acknowledge also that my presentation draws on the work of Dr. Ong because he has done a lot of work in studying this information in our context. And reiterating as well that there are differences among disinformation, misinformation, and malinformation, as Dr. Khan had mentioned. But I want to highlight in disinformation, for example, from a legal perspective, there should be a justification for the regulation or whatever law that may be passed that targets disinformation. And it's not insurmountable. There are ways to do that. I think that the first thing that I would say is that human rights experts in the UN system or the special procedures, for example, will say that we do not punish disinformation per se, but we focus on the agenda and also the intent, which is what distinguishes disinformation from the others, which the intent to propagate false information for a particular agenda. And I say that because that has to be squared with our constitutional framework on freedom of expression and how expression can be regulated. I want to also reiterate the context that is important here, Your Honors, because while we do take guidance or we compare our approach to the approaches of other states, it is important to recognize that those states may not have as robust free expression environment as we do, or have different histories or experiences. For example, if we look to the laws of Germany restricting hate speech, you will understand why their approach on hate speech is that way, a little bit stricter than most because of their experiences with World War II and the atrocities that followed, versus the experiences of the United States, for example, which really is inclined to protect free expression in the widest breadth possible. And on that note, a lot of our doctrine and laws in the Philippines hew towards the U.S. approach, not entirely, but closer to that than, let's say, Germany's approach. In the same way that Canada's approach is different from ours because they have specific values, constitutional values that they want to promote, let's say, the protection of democratic society, which is something that we share with them, but that's part of their legal tests, actually. Okay. So just to reiterate some of the ways in which this information is propagated online, and again, I defer to the other experts on this, but these are the ways, and I think we see them being conducted, being done in platforms and elsewhere in the internet. Social engineering, for example, will employ methods that that recreate or that truncates or changes the context, or context is missing, and of course that also transforms particular content through the use of technology. Okay, and these are some of the models. Dr. Ong's work generated some of the models, and I'll defer to him regarding that. I also just want to emphasize that that companies should be able to see, social media companies, for example, should be able to see disinformation networks because these accounts are interconnected. See, so often because of analytics and the technology that they use, they will be able to spot patterns in their platforms, and that should be visible to them, and especially when these disinformation networks cross platforms. So for example, in the case of Meta, where you have Facebook and Instagram, they can cross platforms, and therefore it should also be visible to those companies, given that they also use algorithms and artificial intelligence to spot those. Okay, so again, Your Honors have already stated the effect of disinformation on our institutions. I will not reiterate that, just to also say that it also has an effect on the population and could be counterproductive to all the other education measures that we have been doing, which means more education than is called for. Okay. So these are some of the strategies that have been offered, and we'll discuss them briefly in a little bit in the context of how other countries approach it. My contribution to the discussion would be to echo that, of course, expression and content are protected under the Constitution, save under exceptions. And this was why I emphasized earlier that disinformation per se need to be carefully reckoned with, because it's such of a breadth that some protected expression or a lot of protected expression might be covered by a law on disinformation. So, but there are ways again to deal with that from the legal standpoint, in addition to the policy recommendations. So we have fact-checking, of course, platforms do that, although as discussed by Dr. Khan, Mettad taken a different path here. Media literacy. So some studies, let's say this case study from West African countries, tell us that when students are taught media literacy and critical thinking skills, they are able to better combat this information, because the end user or those who are targeted with this information are able to discern the type of information that they are receiving. And so, again, to the point that was asked in the invitation to talk about education, education is really an important part of it, but really tailored education and also in the formative stages, and also the universities will be very important, because critical thinking is also developed at that level, a deeper critical thinking. So, and then some of these also suggested by our experts. Now, I want to turn to the approaches of the countries, our neighbors and those who are elsewhere. Singapore, as mentioned, has a law that focuses on online falsehoods that can harm public interest. And some of the remedies in this law will be correction orders. So I think you scale it. And international law also requires us to be proportionate in our response. So if the response to the type of harm can be remedied by a correction order, you don't need to remove it. A takedown order if it's of a graver nature, and then account restrictions would be imposed on such grave offense. So there are penalties involved there. Vietnam also has a decree on this, and it targets interstate service providers, internet service providers as well, and social media platforms. And one of the remedies is removal of content that they define as illegal. Mexico's government has a fact-checking site. So this is also an important countermeasure used broadly, so that there is a government source that counter-checks whatever information, false information is out there. And Finland, as was mentioned, also have national media education policies and new literacies program. This ties neatly into the whole of society or nation approach that was mentioned earlier, because this cannot be addressed by one single law only and penal law only. It also has to be proactive in preventing future susceptibility to this information. Nigeria has a private effort called Africa Check. Canada has anti-online disinformation that has tools relating to different types of specific areas where disinformation happens. And the Netherlands also has a program like Canada and Finland, and they assign this to various ministries. Australia uses a task force to monitor this information. And again, the importance of a media literacy campaign that is meaningful and not just, something that you post online and you leave that there. So it has to involve stakeholders like our educational institutions. France has law on election misinformation, so it's very specific and defines particular terms, which we'll turn to earlier. One of the more significant regulations will come from the European Union through the Digital Services Act. Here, the focus would be on platforms, large platforms. I think the threshold is 45 million users or subscribers. And there are certain obligations that are imposed on those platforms for them to be able to operate in the European Union. And just to recall as well that the European Union is an economic union for the most part, and so that's the target. But it also protects EU citizens from harm. So they are obliged to do risk assessments those companies to report those risk assessments and to be audited by an independent third party. So, and then if not, then there will be consequences. There will also be penalties there. Germany has a law, as I mentioned earlier, but the context is different. So this is a summary of those. To turn to our approach, and I will go quickly because, of course, as members of the House of Representatives, you are very much aware of these. But we have unprotected speech in our constitutional framework that is already existing. So as mentioned earlier, libel and defamation. So some of the ills or the problems that had been mentioned earlier might already be covered by unprotected speech. So these things, of course, Congress can legislate on, can amend the laws that we already have based as well on case law that the Supreme Court had released interpreting some of these provisions. So these would be helpful guideposts in what is unprotected or protected. The rest that are not covered by those would be protected. And so if Congress, the House of Representatives, decides to pass a law that restricts expression that is not covered by those which are already unprotected, then that law must be analyzed or must be crafted with foresight in mind that challenges to the law that restricts expression might have to contend with these particular tests. And I will not discuss all of them, but the most relevant for us, the Brandenburg test, which is recently reiterated by the court in the anti-terrorism law case, might not be as relevant here because that speaks of incitement. But what is relevant here might be the clear and present danger test. So here, as we can see how the test is formulated, Congress has the right to legislate on an evil that the government has a right to prevent. So that can be very broad. But that legislation can only pass muster, constitutional muster, if, again, the danger is clear and it is present. So my point there is for the legislation to be very, very clear in its policy declaration and in the provisions with respect to the danger that is being addressed and the imminence of that danger. It cannot be something that is hypothetical. And so those are some of the tests that we have, Your Honors, and I'll be open to questions on them later because in the interest of time. But one of the international laws that also govern state conduct is the International Covenant on Civil and Political Rights. Here it allows laws that might have an impact on speech as long as it satisfies three tests. The first one is legality. So that means that the law's definition have to be very clear so that the citizen, who in this case we may have an issue of trolls or influencers that will bear the impact, know exactly what conduct to avoid. And that shouldn't also lead to chilling effect. And then the legitimate aim is covered because public order is one of the legitimate aims, as well as respect for the rights and reputations of others, and necessity and proportionality. So the fines should not be too exorbitant, or imprisonment should not be too exorbitant that it's no longer proportionate to what was, let's say, it's misinformation or malinformation as opposed to disinformation. Meta strategy was also discussed earlier. So just breezing through, maybe I'll end here with the final points on what the U.S. had done. The U.S. Federal Trade Commission Act declares that unlawful, unfair, or deceptive acts or practices that includes influencers. And part of the practice guidance here is for disclosures from influencers. I think we've also heard about this case about the TikTok ban in the U.S., and that's coming from a law that protects U.S. citizens from foreign adversary-controlled applications. So this requires divestment, if you want to continue operating in the country, divestment of the foreign adversary's stake in the corporation or in the application. And that is narrow here because they define who exactly is a foreign adversary. So they identify particular countries. In the case of TikTok, they identify China. And so these are some of the proposals that were mentioned earlier. I will no longer repeat them, but I am open to questions of Your Honors later. I think the final point is that artificial intelligence might be leveraged for this, but it's a double-edged sword because artificial intelligence had also been used in that disinformation strategy. Thank you very much, Your Honors.
Okay, thank you,